Hello, this is Congressman Phil Gingrey coming to you on December the 13th, Monday, from Washington this week from the 11th Congressional District. Hope everybody back home is staying warm. That chill is heading our way. It's 31 degrees up here today, but I know that you've been much colder. Well, the lame duck continues. As I say, this is the 13th of December, and we may very well be stuffing our stockings soon up here in Washington. And hopefully we'll get some meaningful things done. But I wanted to talk to you a little bit about the District Court judge decision in the Eastern District of Virginia, Judge Hudson, in the lawsuit that was brought by the Attorney General of Virginia, Ken Cuccinelli, against Kathleen Sebelius, the Secretary of Health and Human Services. And this, of course, is all about Obamacare, and in particular the constitutionality of a provision of that bill passed, as you know, back March of this past year, and the provision that requires individuals, maybe against their will, to purchase health insurance under the guise of the ruse of the Commerce Clause. I think it's a violation of Article 1, Section 8. If you look at it and read carefully, obviously the federal government has the power to regulate interstate commerce between the states, between countries, but to say that someone who is not engaging in commerce, i.e. the purchase of health insurance, or anything for that matter, that the federal government would have the authority, as they claim to under this law, to tell people whether they want to or not by the year 2014, not only would they have to purchase health insurance, but they would have to purchase the insurance that the federal government dictates is sufficient. And so that's what the lawsuit was all about. The judge ruled in favor of the Attorney General of the Commonwealth of Virginia and said, no, the federal government doesn't have the right to do that under the Constitution. In fact, that's unconstitutional. This case probably, I have no doubt, by the Obama administration and its Justice Department will appeal the judge's decision to the Circuit Court of Appeals, and ultimately it will wend its way to the Supreme Court. Quite honestly, I believe that could be a 9-0 decision by the Supreme Court just on the constitutionality issue, nothing else. But one thing that Obamacare has a great problem with is there's no severability language in the 2,400 pages that would say, well, if one section, that is 1501, the section requiring individuals to purchase health insurance, if that were struck down as unconstitutional, if there were a severability clause in the bill, then the rest of the bill would go forward. But there is no severability clause. So I think very likely that this bill is going to be determined unconstitutional. It's going to fall apart. In the meantime, American people, I think, have spoke loudly on November the 2nd. They want me as a physician member and all 435 of us, quite frankly, to repeal this bill, to work hard for health care reform, and we'll do that, but we can do it without having language that's unconstitutional and spending $1 trillion in the process. Well, that's enough for this week, but it's always great to talk to my constituents in Northwest Georgia, the 11th Congressional District. I look forward to getting home soon, maybe in time for Christmas, but in the meantime, we'll stay right here doing the people's business. Thank you all, and God bless you.